Thank you, Marcus, and good morning, good afternoon to those who have joined us. I want to take a minute to give a special thanks to the many clients of the firm that are participating in this webinar and who support our programs so enthusiastically. Without you, none of this would be possible, so thank you very much for joining. And those of you who have heard me speak before on presentations, webinars, and other events may have heard me talk about other topics involving technology law, but there is not a topic that I enjoy presenting on more than the topic of defending software audits. It's something that I've been doing for a long time and that I'm very passionate about, and that I'm very eager to share my thoughts and ideas with you about it today. You know, the types of software audits seem to be evolving all the time. For every new flavor of audit that I see, it's one that's being added to a list or a variety of different types of audits. They run the gamut from contractual verification audits, which typically involve independent third-party auditors, typically large accounting firms, all the way to trade group and audits where publishers come together and give trade groups a power of attorney to do enforcement, and they run self-audit programs, and a variety of flavors in between, SAM engagements, contractual license reviews, all kinds of different flavors of audits, but they all really boil down to one thing, which is a review of the customer's license deployments as against the license entitlements with the overlay of the applicable licensing rules. And so we'll talk about the types of audits. We'll talk about the legal issues that arise in those audits, primarily issues of contract and copyright law, and the common mistakes that clients make and that I've seen made in cases that I've worked on and been involved with over the years. Hopefully there'll be some lessons learned in that. And then a little bit about what the successful audit defense process looks like. What are companies doing effectively to respond to the increased threat of software audits? And so we're going to talk through that as well. Let's talk a little bit about types of software audits, the independent and third-party audits. In this group, we've got software publisher conducted audits. The best example of this is Oracle LMS audits. This is a division within Oracle where they employ the auditors, and the auditors within the staff do the work. Publisher-initiated audits conducted by Big Four firms. I would say the best examples of this are the model that IBM and Microsoft use with their auditors, including KPMG, Deloitte, E&Y. All of the big firms have contract compliance groups that are working for software publishers to help them generate revenue in connection with audits. Microsoft SAM engagements, for those of you who are not familiar with the acronym, SAM stands for Software Asset Management. An audit by another name conducted by a third party who's on the payroll of Microsoft, who's contractually obligated to share the results with Microsoft, and then passes the results to Microsoft, who then negotiates with the customer about trying to close those gaps. So what you see here is that many publishers are auditing their companies through multiple flavors. So we'll look at Microsoft. They use the publisher-initiated audits in connection with their enterprise agreements. They use their software publisher-conducted audits in connection with their service provider license agreements. They use the SAM engagement, primarily targeted at enterprise and volume license customers. And they also participate as one of the primary members of the BSA, the Software Alliance, a trade group that is charged with doing enforcement under power of attorney. The only one on the list that Microsoft doesn't do is the last one. They're not members of the SIIA. In fact, it was their departure from the SIIA that created the BSA. And so if you're audited in an SIIA matter, Microsoft will not be involved, but other publishers will. So what you see here is that the variety and type of audits are increasing. There's an ever-evolving threat at the individual publisher level as well as across the portfolio of publishers in the typical enterprise company. And whereas 10 years ago, large enterprise companies were primarily immune from audits unless there was a really significant problem with the relationship, auditing of enterprise software license agreements has become commonplace. Companies like IBM say that they're going to audit all of their customers. And they're not singling a particular customer out. The audit should not be perceived as a message by the customer as an indication that the relationship is troubled. It's just part of the new way. So everybody is being audited by everyone. And you see, publisher and third-party auditors, we talked a little bit about this. You know, one of the things about independence, we have a lot of clients in enterprise agreements who have a division, maybe in a foreign country, that gets approached by the BSA. And I look at their EA and I see the compliance verification rights require that the auditor be independent. And I say, well, you can't have the BSA audit me for Microsoft because it runs afoul of the independent auditor requirement in my enterprise agreement. And so it's important when you see the word independent to understand what that means. That is a term of art. And many times the independence test of a particular auditor can be challenged. And so you want to make sure that you don't just accept the auditor that gets announced. To treat SAM providers as auditors. I have been advising my clients to opt out of SAM engagements since the SAM engagement was created. I have never seen a client get a good outcome in a SAM engagement, and I generally work to avoid SAM engagements by opting my clients out and having them choose a different approach for software asset management. Even audits that are narrow in scope can be very disruptive and invasive, and we're going to try to talk a little bit about how to make that better today. Let's talk about the BSA. This is really how I got my start. The BSA audited a company that I was working with. I was the CEO of, and I'll never forget receiving that letter from Washington in a UPS package announcing that we were being audited and threatening us with up to $150,000 per violation. I had a sinking feeling, like a sick feeling in my stomach, and I couldn't sit down to read it. I was standing up at my desk, and I had this terrible feeling as I was reading the letter. And it's that feeling that got me started in handling BSA cases now 12 or 13 years ago. And those of you who know about our firm know that we still handle a lot of these cases and are still fighting hard for the little guys that are frequently the target of these agency audits. These agency audits are not targeted at enterprise or mid-market customers. This is an SMB strategy. The largest case I ever had in the BSA was 2,000 computers. The vast majority of the cases that I have are under 100 computers, and so we're really talking about a strategy for SMB, and most of the, quote, leads that they get are in response to radio advertisements, billboards, social media advertisements, promising vacation money, wouldn't you like to go to the beach, turn your boss in and get money for Christmas. So aggressive marketing to get disgruntled employees and former employees to come forward and make a tip and then share in the recovery. this process has been distasteful to me since it was used initially, and I've never become comfortable with a strategy where you're paying, in many cases, the only or one of two IT people within a company charged with managing IT, paying them to turn their bosses in for the promise of reward money. It's just a practice that has always kind of not sit well with me, and my experience with that first BSA case is still a very vivid and wildly negative experience for me, and it's something that I never want my clients to have to feel or experience, but unfortunately the BSA is still very active, and they continue to go after companies. As you can see, some of these numbers and cases are very old, but I wanted to give you a sense that this is something that's been around for a long time, and that overall the settlement fines and the activity of this organization continues to grow and continues to be a major risk factor for SMB businesses. The SIIA, similar company, actually the predecessor, started the self-audit model in the early 90s, and I give credit to the lawyer who created it. It's had something that has endured the test of time and has generated a tremendous amount of wealth and income to the members of these groups, and it's something that they continue with. Like the BSA, they have historically offered reward money. One of the differences is that in some SIIA cases that I've been involved with, the lawyers are compensated on contingency fee as opposed to fee for file or other models, and it sometimes changes the nature of the behavior, the way the cases are handled, and whether or not the cases are brought to court. So I would say on a percentage basis, you're more likely to wind up in court on an SIIA case than you are a BSA case. The other thing to think about here is that the SII and the BSA are in competition for leads, and there frequently is an overlap between a disgruntled employee that will make a complaint to both groups. And so we've many times had cases where we had the SIIA come along first, and then we had a BSA case, and since the SIIA doesn't represent Microsoft, we wound up with an SII case and a BSA case running side by side. And so that, imagine how bad one case could be, but dealing with two at the same time can be even a bigger pain. And the other thing with the SIIA is my experience is that they're upmarket a little bit. Tend to see 250 to 1,000 computer environments being targeted by SIIA, whereas these matters, for the most part, will tend to be larger. The other thing to think about with SIIA is that Autodesk is probably one of the more influential members along with Adobe. And so you're more likely to be facing a major issue with the SIIA over Autodesk and Adobe, whereas with BSA, the primary publishers in question are more likely to be Microsoft and Adobe. So what are the legal issues that arise in software audits? Well, the most important thing to think about is that the licensing terms establish the contractual framework for the interpretation of any dispute. So you start with contract law. Is there a breach of the license agreement? If so, what does the license agreement say about remedies, termination, rights to audit? All of those issues are contract law issues. And so you can't really deal effectively with a software audit matter unless you have a full picture of the contract relationship. And those of you, and my clients that are on the line and others that work in large enterprise companies, you'll recognize the fact that it's not always easy to get your hands on the contract relationship. Many vendor relationships span many decades and across many documents with multiple amendments. sometimes across multiple owners. So you start out and one company owns the vendor, and 10, 15 years later it's changed hands 2 or 3 times. And multiple agreements at multiple times, and you have a very difficult time just getting through what I call the contract soup to understand the contractual relationship with the parties, which is a foundational issue for dealing with software audits. Why? Because the primary legal issue in a software license dispute is copyright infringement liability, but you can't understand the contours of the copyright infringement issues without an understanding of the contractual issues, because the contractual license grant, for example, extends the outer boundary of where the copyright infringement claim would start. And so if you don't understand the contract issues, you can't understand the copyright issues. But when you get to court, it's all about copyright. Never been involved in a litigation case where there was an issue over software licensing that arose either in connection with a software audit or in relation to an issue involving license rules, where the primary theory of the case was copyright infringement. And the main reason is copyright infringement has a lot more teeth and a lot more benefits to the publisher than the typical state breach of contract law would provide. The other thing to think about is that, we've got a different set of rules due to preemption. The effect of the supremacy clause in the Constitution makes the copyright laws supreme over any contrary state laws, including corporate formation laws or other laws that allow people to operate with limited liability. And therefore, what we see is a different set of rules on a federal level than what you would expect to see based on state laws around an individual's ability to be reached for liability for officers and directors, where you would typically think that those individuals would be immune from liability under state law because of the benefits of the corporate veil or limited liability structures, as well as different rules regarding successor liability in connection with mergers or acquisitions. And this is a challenge I face with my large clients. As you can imagine, the clients that I represent sometimes own hundreds, if not thousands, of entities, and they don't get to have that many entities without having an active business of buying and in some case selling businesses. And when you get into a situation where you're dealing with buying and selling businesses that involve IT assets running software, you run into a lot of problems around proper transfer of software licenses and the ability to transfer licenses or the lack of the ability to transfer licenses and the resulting liability, which attaches at the time of closing. So if you buy a company that's out of compliance, when you close on that company, in most situations, the buyer of that company is going to be exposed for copyright infringement liability at the time of the closing. And so successor liability issues come up a lot involving software licensing, and a lot of audit matters happen in and around M&A activity. I don't think it would surprise many of you if I told you that some in the software industry are trolling information about their clients in connection with M&A activity, and when they get wind of it, they try to get in line to get some of the money or to get in the way of a transaction and to be forced to be paid off in exchange for some sort of accommodation that will allow the transaction to go forward. So what are the common mistakes that people make? I would say that the biggest mistake that people make is not to be cautious in connection with audits. it sounds a lot like we have nothing to hide. We know we're doing a good job of managing our licenses in the spirit of partnership and transparency. You guys could come in and do whatever you want. If you want to audit us, fine. Come on. And I've got a lot of clients, particularly who, as a general proposition, have as part of their values transparency. Their corporate culture is one of cooperation and partnership. And those types of companies that allow those types of strategies to manage their approach to software licensing, vendor management, and audit defense generally wind up with the worst outcomes. And the reason for that is that the publishers and their auditors are not acting in good faith. They're there for the money. They're there to build a case to allow the publisher to charge you more money. And the one thing that I've learned in over 500 cases is that it's all about the money. And therefore, if you're going to set up a program to mitigate your financial risk in connection with software audits, you have to be more circumspect in the nature of the way you approach the audits, what kind of policies and procedures you put in place to deal with those audits, and make sure that you know, or that you have people on your team that know, that a lot of these issues are subject to negotiation. So failure to negotiate the audit process is first and foremost the mistake that I see. We often are successful in narrowing the scope, the timing. In many cases, we negotiate to avoid the audit altogether. These are things that you need to be thinking of. You know, when you get an audit notice, your first reaction is, how do I make this audit go away? I don't want this audit. Make it stop. The other thing that we see, common pattern, my IT guy got a notice. I was out of town. He decided he was just going to handle it, and he ran off and ran some scripts and provided them to the vendor. I didn't get a chance to review them. They contain factual inaccuracies. Now we have a big demand from the publisher, and we don't know what to do now. Documentation. You know, the classic case, someone gets audited, they run out and they buy a bunch of software for whatever they think they need. Then they do the audit and they produce all the proofs of purchases that show that they made purchases 1 week after the audit notice. Not helpful. Failure to produce audit results as of the effective date. You have to understand, and any time you're dealing with a software audit, what is the window? What is the time frame? What set of data are we agreeing to do the analysis on? In most cases, particularly third-party cases and agency cases, there's an effective time, whether it's the effective date in a BSA case or the audited month in a publisher enterprise case. There's a time period. And you must make sure that your audit materials, both in terms of your discovery data and your entitlement data, align with that time period. What was deployed and yet removed prior to that effective date, that which was deployed or removed after that effective date, that which was purchased after that effective date, will have no bearing on the correct analysis. And this is a common mistake that's made, looking at the wrong data for purposes of doing the analysis. I already mentioned that I definitely don't recommend, and this is interesting because I think it's a bit of human nature. You know, someone says, hey, you don't have enough licenses. You look at it and your immediate instinct is to buy licenses. A lot of legal fees have been unnecessarily consumed while people were following that particular instinct. And so it's one that I always caution my clients to avoid. In most cases, buying now is counterproductive from a cash flow perspective. It violates the admonitions in the letters that the publisher sent, which typically include spoliation language to the effect that you shouldn't buy or uninstall in response to the letter. One of the things that I learned early on is that when clients were calling me, they didn't really have a good insight into how a software audit affects the various organizations within the company, and most importantly, really didn't have a good idea of how long they take. And so I prepared this graph to show, by department, which areas are affected and how. And then across the bottom, I've shown a sort of audit effective date to settlement time frame, which I generally would tell clients can be up to 18 months. And I've got cases that have been going on way longer than that. And of course, there are some that we resolve within 3 or 4 months. But I generally think this is a helpful chart to show that the proper response to audits, the proper policies to implement involving audits, involve a multidisciplinary team comprised of professionals from the business, legal, IT, finance, and procurement. And if all of these people don't have a seat at the table in your audit response process, then you're probably leaving some value on the table. And you might want to take a look at reevaluating your approach to software audits. Similar chart here, just showing not organizational impact, but where the costs are. So this shows which area is affected. You see, IT diversion, very heavy involvement with IT in dealing with software audits. You see the legal fees, obviously, across the board. Licensing fees will typically come toward the end, where you either have to buy or uninstall or negotiate a new license agreement. Financial resources, this is one that I think is sometimes underrepresented on teams that I work on. And then publicity. What is the reputational impact? In many cases, we will negotiate for confidentiality provisions that prohibit any public disclosure of the existence of an audit or how that audit was settled, because we do not want any of our clients to be subject to negative publicity. And part of the marketing operation, particularly for the trade groups, is to issue periodic press releases naming names and talking about investigations. And so you can imagine what your business folks or your corporate communications folks would think about reading something like that. So when you think about the audit defense process, I think that the fundamental issue is around deployment data, software discovery. Many of my clients have overspent and been overpromised about the value of discovery tools. And while I am generally skeptical of the limited value of discovery tools, I recognize that automated discovery is a requirement in every meaningful software audit, whether it's an internal review, whether it's a third-party audit, a SAM engagement, it doesn't matter. Good automated discovery data that can withstand completeness and accuracy testing in the manner that a typical auditor would subject it to is necessary first step. It doesn't have to be expensive. In many cases, we're having our clients run free tools, the same free tools that auditors will use. In other instances, we find that our clients already have tools that could be leveraged for purposes of getting the deployment data that's necessary. We generally find that on the discovery data, we spend 80% of our time chasing that 20%. And so my clients always ask me, Rob, when are we done? What is our target penetration as a percentage of known devices? When can we say our discovery is complete? I tell my clients 95% for a large enterprise is a reasonable target, and that there would be little value relative to the cost in chasing that last 5%. So if you can get discovery penetration in a large enterprise, and it doesn't have to be from a single tool, it can be from multiple tools that can be aggregated together, but if you've got 95% discovery capability for your devices, you're doing well. If you've got less than that, you're not doing so well. If you've got none, you're in trouble. If you can't go and get an automated discovery of the software installed on your computers, you're in trouble. And you need to start working to remedy that right away. Proof of purchase analysis is difficult because in many cases, outside of the enterprise agreement where the vendors are doing more to help you manage your purchases, on a lot of software vendors, it's difficult to get a picture of the entitlements. And so there's a lot of work that goes into gathering proofs of purchase, invoicing data, and you'd be surprised at all of the things that you would think would be good proof, but they say isn't. For example, an end-user license agreement is not good proof. A certificate of authenticity, the most official sounding thing you can think of, is not good proof of a license. So what is good proof? Dated proofs of purchase in the name of the entity claiming entitlement that specifies the product, the edition, the quantity, and the price paid, as well as the date. That's good proof. Electronic records, downloads from vendor portals, Dell reports, CDW reports, reports from SHI, all good records. So knowing what is good proof and implementing policies and procedures to make sure you can put your hands on them easily to perform the reconciliation work is the key. The most important service that our law firm provides is taking data from clients about what they have deployed and what they've purchased and cobbling that into a report that can be discussed with business people that has dollar amounts in it that show this is what your license position is and this is what your financial exposure is as a result. If you think about it, the vast majority of our engagements are built around delivering that report. Once you know what your gap is and what your exposure is, then you begin to think about, okay, what am I going to show the auditors? And there's a step here that's not disclosed, but before we make that step, we want to make sure that we've got an agreement in place. I call it a 408 agreement. Some people call it a 408 plus agreement. For those of you who don't know about 408, it's the federal rule of evidence that deals with information exchanged in connection with settlement discussions. It's designed to protect the information that's being shared in terms of the audit materials, because absent such an agreement, the vendor could use that information against you in court, and if they were already in court and doing discovery, they couldn't ask you to prepare that report. So as the audited entity, you're agreeing to do more than you would be obligated to do under discovery, and therefore in exchange it's reasonable for you to demand a 408 agreement before any information is produced. And this goes for Third-party auditors that want to rush your people into going to kickoff calls? No 408, no NDA, no kickoff call. Producing the results is the one area where lawyers frequently get fired in software audit matters. I can't tell you how many cases where I was the second or third lawyer hired because the lawyer that handled the case before me did not do a good job of calculating the client's financial exposure, did not do a good job of vetting the results that were produced, and when the publisher made the demand, the client was shocked, very upset with the lawyer, and terminated the lawyer. So if you're producing results from audits, the lawyer's role is not to forward the work that the IT people put together. The lawyer's job is to make sure that the business people understand the financial implications of the work that the IT people put together and to understand that the auditor is going to see the data in a much different way than what your internal people might interpret it to mean from a financial perspective. And making sure that everybody understands to the extent possible what the financial implications of producing the results are going to be before they're produced, not after. Typically, after the results are produced or findings are made, there's a phase where you enter into negotiation. This could be a handoff procedure where the auditors are handing off the matter back to the vendor and then the vendor makes a financial demand. It could be a direct. If you're dealing with an agency, this would come directly from the agency, but they're going to make a demand, a financial demand, and then there's typically negotiation. To me, the negotiation is about three things. One, factual inaccuracy. Did you interpret my data correctly? Did you say I have more deployed than I have? Did you give me credit for all of my licenses that I've purchased? Right? And then the rest is about how are you interpreting the financial ramifications of the deltas? We could agree that I may have one over-deployed, but disagree on what that means from a financial perspective. Does that mean I have to pay you 3 times the retail price plus your attorney's fees? Or does that mean I get to uninstall it because I don't need it? Or does that mean I get to go buy it from my vendor at my historical discounted price? So a lot of this is subject to negotiation over both factual, legal, and financial matters, and that's why the negotiation phase of the software defense process can take many, many months. When you get down to settling a case, the one thing that I tell people all the time, and it seems like car accident lawyers understand this way better than technology lawyers, is get a release. If you're writing a check to resolve a dispute, it only makes sense to me that you're closing out that period for future disputes. So you want to make sure that you're getting a release. Releases are hard to get from software companies. They don't like to give them. But you need to negotiate for a release in exchange for writing a check. The other thing you need to do with settlements is make sure that whatever the licensing terms or ambiguities or issues that came up that gave rise to the dispute are resolved. Because you never want to settle a case involving a software dispute unless you can say to your client, with this settlement, we'll be in compliance. The worst thing you could do, for example, is take the vendor's numbers or the auditor's numbers, which you know are wrong, settle on that basis, and then be out of compliance immediately when you're done. So get a settlement that includes a release that puts your client into compliance when it's consummated and that resolves and cleans up any terms and conditions issues that led to the problem in the first place. Discovery is a very challenging thing, particularly in the large enterprise. Networks are often configured for security reasons with firewalls that make it difficult to deploy discovery tools, and it is a challenge to do. Making the right selection, I think, is critically important, and I would tell you, my clients, leverage what you have. Don't go out and buy huge packages with long-term deployments to deal with the risk of software audits. If you need those tools for other IT issues, fine. But a point solution is frequently a better option, or a data set that you already have from another source within the organization is typically a better option than a massive software asset management package that's got all the bells and whistles on it. Your proof of purchase analysis. This is something that you definitely want to start working on early in the process. I think a lot of clients will wait until the discovery is done to begin digging into gathering entitlement information, and I think that's a mistake. I think you should start working on a parallel track when you're dealing with a software audit to focus both on entitlement documentation review and compilation while the discovery is proceeding on a parallel track. There's no reason to sequence the two separately. Obviously, they are related, and ultimately we will have to reconcile the two data sets to create a gap analysis. And the gap is the financial exposure. It's the gap plus the known approach to fines or penalties or settlements that creates the financial exposure analysis. And you see, again, that bottom bullet point, calculate the potential fine exposure for the client prior to producing the results. The other thing to think about is license types, use characterizations, and downgrade rights must be considered. This is not a straight, I've got one deployed and I've got one licensed, because the licensing rules are complicated. How you use the software could determine whether or not a particular deployment should be counted as one or not, or two. And so it's not a straightforward mathematical formula. And so license adjustments need to be made that take into account the licensing rules. And you can't do a meaningful gap analysis without good discovery data, a thorough understanding of the licensing rules and how they apply, along with an understanding of what good entitlement data we have, so that now we're looking at the gap analysis through the same lens as either the vendor would or the vendor's auditor would. And what I would tell you guys is SAM providers, whether they're in-house or third-party, do not look at the data the same way as auditors. An auditor is going to use every method possible through extrapolation and otherwise to reach the result that gets the vendor the most money. The software asset manager, either in-house or as part of a consulting engagement, is not going to use those same assumptions and inferences. And so what you don't want to do is rely on your SAM fact-finding, SAM assumptions, SAM entitlement review, and go from that to a conclusion about your exposure analysis. You've got to take that data set and subject it to the rigor of completeness and accuracy testing and the types of assumptions and interpretations that auditors will make in order to create a real exposure analysis for the client. We talked about the 408 agreement as a precursor to producing audit materials. I think that has become fairly well known at this point and as a best practice. So I definitely recommend that you incorporate that into your process. The other thing that we want to make sure that we're doing in terms of the audit materials is understanding that the data set that we're focusing on is correct, both in terms of geographic scope, There's no related entity data in it. We've got, the right time set for data. We don't want, for example, on an audit that's effective date snapshot in time for February 1, we don't want to include running discovery data that includes products that could have been installed in January but got uninstalled before February 1. And so understanding the data, making sure the data aligns with the scope of what we're investigating, and making sure that we're constantly looking to limit the scope of the data is critically important when you're evaluating producing audit materials. The other thing I mentioned earlier, but I'll re-emphasize, is, for example, on an effective date audit, you're not trying to use purchases that came later. Look at your proof of purchase relative to your effective date. The other thing that you don't have to do is you don't have to tick and tie licenses to deployments at the individual level. In general, in a software audit, you're looking at gross installations of a particular product against gross entitlements. You don't have to get down to ticking and tying to each individual user or device in most situations. Start with an analysis of the totals. How many of this product do I have deployed? How many total entitlements do I have? The other thing is get client and business people approval before you produce the final results. If you're going to produce something, you want to make sure you've got a financial exposure analysis linked to it, and that the people, the stakeholders who are going to be writing the checks have an opportunity to see that and understand those anticipated financial repercussions before you send them to the vendor or the auditor. That's this last point. Go to the client. Go to the stakeholder. Go to the business unit. Make sure they understand the financial implications of what you're about to produce. What I have found is that if there's a big price tag on it, they take more time looking at it. They help you vet it before you send it. Whereas if the price tag only comes later, then they want to start doing a bunch of digging when you finally give them the bill and tell them how much it's going to cost. Give them the bill early. Make sure that they understand the financial implications of what you're about to send in before it goes in. When you're negotiating, be careful to understand that the auditor's analysis in almost every case is subject to dispute. I've never been in a case where I looked at the auditor's findings and said, oh yeah, all that's fair, all that makes sense. There's nothing there that I would have done differently if I was trying to be balanced and fair as opposed to one-sided. So part of an audit defense process is developing a process to challenge the auditor's findings. When the auditors find, except in a self-audit, which you don't have, other than in a self-audit, anytime there's an auditor, your job is to be a check and balance against that auditor's findings. You have to understand the assumptions they made, the data they used, the manner in which they made their calculations. Because in every instance in my experience, particularly the big firms, they've got processes baked in to lead to inflated findings. And then they give you very little time and this giant deck of a spreadsheet to say, go tell me why it's wrong. And you've got to be ready for that. Because if you're not ready to go tell them why it's wrong, the publisher's going to get their findings, and if you haven't challenged them on a timely basis, they're going to say, the audit is concluded. The auditors used your data. Why didn't you object then? We consider the audit portion to be closed. In other words, you waived it. So you don't want to be in a position of having to argue about waiver, and therefore you've got to have the right people shadowing, monitoring, feeding information to, and managing the auditors. And if you don't have that, then you're going to put yourself in a position where you're scrambling to disprove negatives, where you're back on your heels with a big compliance claim and not a lot of strong points for your business people and your other teams to argue as they're moving through the negotiation process. The other thing to think about is there are both monetary and non-monetary aspects of settlements. Both are important. It's not just about the monetary aspect. The non-monetary aspect could be things like confidentiality, release, audit forbearance for a period of time. These are important non-monetary considerations that should be the part of each negotiation. The other thing that I have found with the auditors is their fanciful view of the legal issues that govern the software market. In many instances, my experience is that software publishers make arguments and their auditors make arguments without any basis in the law. So, for example, the notion that in a software audit, if there's an over-deployment, the customer should pay 3 times the unbundled retail price of a suite is the most fabricated, made up, and contrary to applicable law approach that could be taken. And so you, as a lawyer, have to be prepared not only to challenge what the auditors are doing, to put the client's factual case forward, but also to be prepared to call them out on these ridiculous legal arguments, mostly around the damages that would be appropriate in a case. When dealing with settlement agreements, we talked about the release, and I would say that's probably very important. In many cases, the releases are conditional. They're conditioned on accuracy of information shared or future performances. You want to be very careful with releases that are conditional in nature. My preference, wherever possible, is to negotiate for an unconditional release regarding the subject matter that gave rise to the dispute and that which is being resolved. Okay? So that's a very important one to think about. Confidentiality, we mentioned. This is not the confidentiality of the audit materials or other information shared. This is confidentiality of the settlement terms that the audit took place. This is no PR confidentiality is what we're talking about here. No future inspections. One of the things that a lot of the agencies will ask for is, well, we're going to settle this, and in a year we're going to come back for another round. Absolutely not. Should be no inspections. There should be no third-party tools being run in an environment, and there should never be an agreement to give third parties access to run tools in a corporate environment. We have a couple minutes for questions. Please feel free to enter your questions in the box. We'll do our best to answer those questions that we have time for. So just taking a second to scroll through. I want to start by apologizing for those that had some technical difficulty early on. First question, when you get a request for an audit, what are the circumstances under which you comply? I generally will tell a client that my preference is to cooperate with reasonable requests, but to do so in a way that does not jeopardize your legal rights relative to where you would be if you didn't cooperate. And so a lot of that has to do with understanding what your contractual obligations are, and more importantly, what is reasonable under the circumstances. So there's no blanket way that I can tell you that you should comply in every situation, other than if their requests are reasonable, then you should consider complying after you've consulted with the various stakeholders from the various departments that I've indicated, IT, procurement, business, etc., That's the best way to determine how you want to comply. But as a general proposition, I'm comfortable with reasonable cooperation, subject to your obligations, and in a way that's not going to jeopardize your legal rights. Next question. If a fully executed license agreement is the gold standard for proof of purchase, but apparently many types of related documentation are not acceptable as proof of purchase, where does the standard come from? If the dispute went to litigation, wouldn't everything reasonably relevant to a demonstration of legitimate licensing agreement be admissible? That's an excellent question, and I think the answer is yes. If I was in court, I could put a client on the stand and say, there was an audit that was done that revealed that you had 22 installations of Microsoft Office on your computers. Is that correct? Yes, that's correct. And did you own licenses for those installations? Yes. Where did you buy them? I bought them at Best Buy. How did you buy them? I bought them on my credit card. What credit card did you use? American Express. Do you happen to have a copy of the receipt from American Express that you purchased on the credit card? Yes. Mark it as an exhibit. Put it in. So the answer to the question is the standard for proof came from the trade groups, initially the SIIA and later the BSA. The reason that they created it is they wouldn't know with their effective date model, if you had a EULA with no date or you had a certificate of authenticity with no date, how would they know when you bought it? So it has no real bearing on what would happen in a litigation case because, as you say, you should be able to put any of that that's relevant in. So that's one area where there's a dichotomy between the rules that govern self-audit and the rules that would obtain in court, and there are many, many examples of that in connection with software audits. Thank you guys for your many questions. Unfortunately, we don't have time to go into any further on this call. I will review your questions and to the extent possible, send email responses